Hello and welcome to the latest Lunchtime Learning. I'm delighted to be joined today by Jamie Shepherd, who is the founder of Soteria Planning. How are you, Jamie?
I'm very well, thank you, Stephen. How are you? Did you have a nice weekend?
I had a lovely weekend, thank you. So I'm excited actually to expand my knowledge this morning. So today is all about understanding believer that quite a few estate agents and actually more important consumer needs help to understand these sort of things. So if we start off with, let's talk about wills. What is a will and why is it important to have a will?
Yeah, perfect. So a will is actually a legal document, okay, that essentially outlines what should happen on your death. Okay, so if we look at everything between, but the main two things on a will would be appointing an executor or executors. So that is the person or persons that are responsible, liable for dealing with your estate, and of course, what happens to your assets. Okay. Now, in between that, you've got things like appointing legal guardians. If you've got minor children, you might need to make provision for businesses. You might want to make provision for pets. You might have funeral wishes. But I would say the two main points, certainly if we're looking at people purchasing property, would be who's going to administer your estate and who's going to inherit your estate. Now, the will actually becomes a legally binding document once signed by the person whose will it is and witnessed by two independent witnesses.
Okay, great. So you mentioned executors. What's the difference between executors and trustees?
Great question. So the executor on a will ultimately take from when the person passes away through to when the estate is administered, and they are responsible for that whole process. Now, sometimes within a will, the role of the trustee could be just during the administration process of the will, or it could be actually furthermore. We'll give you an example. If you've got minor children that are inheriting within a will, and let's say the age of 21, before the age of 21, who's going to look after the minor children's assets? That's the role of a trustee. So the trustee, unlike the executors, will be making decisions. Okay, and the trustee has what's called a fiduciary obligation. That means they are responsible and liable to those beneficiaries to make sure they're making really good really good decisions. Sorry.
Okay, great. So again, coming back to that, so what's probate?
So probate is actually the legal process of dealing with a deceased estate. Now, sometimes when somebody passes away, probate might not be needed. I'll give you an example of that. If you've got a married couple and in their name, they've got one joint bank account and they've got a jointly owned property, on the first death, probate is not likely to be needed. Now, you'll still need to administer the person's estate. You'll still need to remove the deceased person from the bank account, from the property, but you're unlikely to need the grant of probate. In my example, when the second person dies, you will not be able to transfer the property at the land registry without the grant of probate. Okay, so the grant of probate is an application to the court to say, this person has died, here's a valid will, here's a death certificate. Oh, and by the way, here's all the information you need so that they can check if any tax is due, so that they can check if the person owed any money to HMRC during their lifetime. Okay, and ultimately it's getting a grant to say, right, that person's good to go. You as an executor can now administer those assets.
What would it normally take to get that grant?
Right, well, our latest grants, we put 3 in at the start of September, and I think they came back mid-October, so about 6 weeks. Now, that could take 6 months. But I think if you're putting an application in correctly, okay, and you're not likely to have any kind of pushback, you're not going to get anything wrong. You're making sure you send the death certificate with the will. You're making sure you send it to the right place. Yeah, these came back in 6 weeks.
Okay, so that's a really good point, and I wonder whether you could help me. Is it possible to have a checklist that agents can give out to their potential sellers when they're dealing with probates, just to say, actually, in order for you to get it through as quickly as possible, here are the things that you need to do in order to help that. I don't know if that's something you can help prepare for me. Yeah. And maybe that we can give out as some form of freebie. So again, for me, it's all about adding value to sellers when they're going through this process. And a lot of sellers really don't understand. And I think by having this checklist and a piece of paper to say, actually, this, and this, and this, and this, will help you get it. We'll get it through sooner.
100%, Stephen.
The other question then is, if I'm a seller, oh, brilliant. I mean, if you're happy to share that with me, and then I can share it out with people, that would be absolutely fantastic. Okay, no, brilliant. So if you're watching this or listening, if you want a copy of that, please let me know and I will send it over for you. So thank you. Coming back, if I'm a seller, should I put my property on before I get before probate is granted, or should I wait?
Really good question. So I think obviously you've got to obtain the evaluations of the property for probate. I don't think there's absolutely nothing wrong with putting the property on the market, okay, as long as buyers' expectations are being set. Now, when we look at probate, has the application actually gone in? Okay, because when somebody comes to talk to us because somebody's passed away, it might be that actually they're just at the initial stages. And we say to them, well, this is the information that we need. And actually, they're going to take 3 months just to get that information. So probate hasn't even been submitted. But from the application being submitted, it could be as quick as, I mean, I've had people that have done it themselves and done it in 3-4 weeks. So they tell me. So I don't think there's anything wrong with putting a property on the market as long as the seller and the buyer have got an expectation that this is not going to complete until probate has been granted.
Okay, brilliant. So coming back, what's lasting power of attorney then?
Okay, so in this country, Stephen, a lot of people use the term next of kin, don't they? And they think that if there's ever an issue where somebody dies, the next of kin will inherit, or if somebody becomes incapacitated, the next of kin will be the person that makes decisions. And unfortunately, the term next of kin relates to the person that gets a phone call if something goes wrong. That's about it. Now, in this country, it doesn't matter whether you're husband and wife, husband and husband, or mum and son. Okay, nobody has the automatic rights to make a decision for somebody else. What a lasting power of attorney document does is it allows you to appoint someone. This someone on this document is called an attorney. It allows you to appoint an attorney or attorneys to make decisions for you if you're not able to make them yourself. Now, a lot of people, unfortunately, associate this with an older person. They associate this somebody maybe in their 60s, 70s, 80s due to vulnerability, Alzheimer's, old age, dementia, having a stroke. But actually, any of us could have a car accident. Any of us could go running, fall over and hit our head. Now, the implications on anybody in that scenario would probably be the same. We've all got bills to pay. Some of us have got financial dependence. Some of us have got mortgages. Some of us have got tenants. Some of us have got employees. If decisions can't be made for us, the implications are absolutely huge. A very simple lasting power of attorney document could stop any of that potentially being a problem.
Okay, and how easy is that to be done? Where'd you get that information to do it?
So I'm happy to supply you with a very good, if I don't say so myself, PDF document that I've got that you could share with people. Now, similar to probate, a lasting power of attorney could be done via someone like us, okay, or you can do it online yourself. I will just say, doing anything yourself, you have to be aware of the dangers. For example, last week, I had a meeting with a couple. Couple were in their 60s. They wanted to talk about their wills. And I said, do you have power of attorney in place? Oh, yeah, we filled that out. We just need to send it off. They said, it's going to be our children that are going to be the attorneys. And I said, okay, is that your children with each other? And they said, oh, we didn't think about each other. So it's a bit risky doing it yourself if you don't know what you're doing.
Okay. So always take professional advice.
100%.
Okay, let's talk about inheritance tax. So what is inheritance tax? And again, why is it important to plan for it?
I mean, inheritance tax is obviously a massive subject at the moment, certainly with the recent budget and the announcement that pensions are going to form part of your estate. So planning is needed, certainly moving forward. At this very moment in time, every single person has what's called a nil rate band, which is a tax allowance of £325,000 on death. Now, currently, today, there are certain assets that don't form part of that estate. Today, pensions don't form part of that estate. In 2027, in April, supposedly they will. Now, property is a really interesting point because there are lots of people that own property in limited companies, and they think automatically because it's a company, it doesn't form part of their estate for inheritance tax. But it's really, really important they seek professional advice because actually they might get a shock. Now, with regards to inheritance tax, it could be you've got a single person that doesn't have any children and they have an allowance of £325,000, meaning that anything over that allowance would be taxed at 40%. Okay. Now, if you've got a married couple and you've got children and the married couple have got a property, their tax allowance could be as much as £1 million. Okay. Now, again, it's worth understanding what is in that £1 million. Things like life insurance policies, are they in that? Okay. Well, it depends how they've been set up. Okay. Now, inheritance tax is going to be a problem for a lot more of us moving forwards. So I think it's important that people take professional advice. One thing that is really, really important not to do is listen to Dave from down the pub. For example, Dave from down the pub might say to you, transfer your property to your kids. Transfer your property to your kids, continue living there. As long as you do it within 7 years of you dying, it's no longer your property. Well, part of what Dave's saying there is correct, because actually it's no longer yours if you transfer it. But from an inheritance tax perspective, unfortunately, if you continue living there and you do not pay market value rent, from an inheritance tax perspective, HMRC will see that property as yours.
Okay. You talked about 7-year gifting. Is that something that still applies, or has that changed, and what actually is it?
No, it still very much applies. So, for example, let's pretend, Stephen, that you're my friend. Well, we don't need to pretend that, but we can pretend you're my friend. And let's pretend this part. I've got a spare £100,000 in my bank, and I don't need it. I've worked out that for the rest of my life, I'm going to be comfortable. Okay, I can give you £100,000. Okay, no one's going to pay tax. I can give it to you. You can take it tax-free. Now, as long as I live 7 years from the date of that gift will not form part of my estate. Okay. Now, there's a lot of confusion here because sometimes people read the gifting allowance of £3,000 and they think that's all that you are allowed to gift. Actually, that's all that you are allowed to gift without the 7-year clock running. Okay. So people can legitimately gift £3,000 per year. Okay. And it be outside of the estate immediately. But if you gift more than that, if you gifted £100,000 to your child, to your friend, to your family member, then unfortunately for the next 7 years, part of that is going to remain in your estate. It does taper down after a few years.
Okay, fine. Thank you. So estate planning. When should I start planning my estate?
Yesterday.
Okay, and what sort of things do I need to do? Is it everything we've been discussed about sorting out a will, lasting power of attorney, or is there other stuff that I should be looking at?
Yeah, I would say making sure you've got your will in place. And most importantly, if you've got your will in place, make sure it reflects what your current wishes are. Okay. Making sure you've got your power of attorney in place. I would say things like if you've got pensions, okay, whether you're currently paying into a pension with your employer or from previous employers, make sure you've nominated beneficiaries for your pensions. If you've got life insurance policies that maybe are covering children or debts or mortgages, then make sure you've nominated beneficiaries for those if they're not joint policies. If you've got death in service benefits through your employer, make sure you've nominated beneficiaries for that. Okay, that's really, really important. And then just from an estate planning perspective, as you said earlier, if I died tomorrow, it's okay me having a will. It's okay the executors knowing where that will is. But actually, why don't I give them a little understanding as to where to find everything? Would they know about my 10 different bank accounts and my 5 different pension pots and my insurance policies? Would they know all of that? Well, they can find it all out. There are solutions out there for you to be able to find that without trawling through hundreds of pieces of paper. But actually, how can I best prepare them in a safe way? How can I best prepare them? The amount of times that people speak to me and say, oh, dad passed away. He was a really organized person, yet probate has taken 2 years. He'd be horrified at this. And it might be that dad did everything, but dad didn't tell people where it was, potentially. How can we make the future people better at this process?
Okay, so for people here who are, you know, again, you talked about nominated beneficiaries. So from a layman's term, what do you actually mean by that?
So if you've got an insurance policy with work, for example, sometimes as an employee, you receive like a death in service benefit. If you were to die, a multiple of your salary gets paid out. The nominated beneficiary or the nominated person is the person that would receive that payout in the event of your death. The same with your pension pots. Sometimes some of us have pensions that if we die and we haven't taken the money, if we haven't actually physically spent the money ourselves, the pension pot will pay out. Now, who do we want that pension pot to pay out to?
Okay, and how easy is it just to organise that, or is there something that you've got, you know, gain paperwork just to help people do it?
That would usually be done directly with whoever is holding the pot. So, for example, if you've got a pension with Royal London, you would do it directly with Royal London. And I use Royal London as an example. I've got a pension with Royal London. There's an app on my phone, and on the app, you've got the ability to change the beneficiaries however you want.
Okay, lovely. So final question, what is court of protection and deputyship?
So court protection or applying for a deputyship is through the court protection is if somebody loses mental capacity and there is no lasting power of attorney in place. So a very, very well famous example of where this had to happen recently was Kate Garraway. Kate Garraway's husband unfortunately had an illness during COVID. I think he maybe contracted COVID. I believe there was no lasting power of attorney in place. She had to apply for deputyship through the court protection. It took ages, cost a lot of money, and unfortunately, she wasn't allowed to do what she needed to do.
Okay, so again, when should you start looking at that court of protection and deputyship?
So as long as you've got the LPA in place, you won't need court protection and deputyship.
Okay, lovely. Are there any questions that a layman should be asking you now that I haven't asked?
Yes. So certainly from a buyer's perspective or even a seller's perspective, when should you be looking at writing a will? And I would say when you're in your process of purchasing the property, because as soon as you've purchased the property and you've moved in, the will's gone out the window. Okay. At the same time, you've got your mortgage offer. The same time you're sorting out your life insurance to cover the mortgage. That's when you should be putting the will in place. Okay. Now, in terms of who should you use to write a will? You should use somebody that you trust. Use somebody that comes across and communicates to you, okay, how you want to be communicated to.
You talked about buyers, and say I'm buying with my best mate. Different forms of trust there, or different forms of agreement. What are they?
Yeah. So if you're buying a property with someone, most of the time there'll be 3 different types of ownership. You'll have joint tenants, which essentially means you own 100%, he owns 100%. That's typically how a husband and wife might buy a property. You've then got tenants in common in equal shares. So tenants in common in equal shares typically will be 50% each. Or you've got tenants in common in unequal shares. And typically you'd only go down that route if one of you put in more than the other, or if one person over the other was taking more of the income, if it was a rental property. Okay. Now, it's really important to understand from an estate planning perspective, if you and your friend buy a property together as joint tenants and you've got a will that says all of my assets get left to X, actually the property that you've got with your friend will not form part of your will. The property will pass to your friend because of the ownership style it's selected.
Okay, really interesting. So thank you for giving me a better understanding of all these things. If people want to get hold of you, how do they do that, Jamie?
So I can be found on LinkedIn. My website is www.soteriaplanning.uk, and I'm sure you'll share my contact number or contact email address after this anyway.
Brilliant. Okay, well, look, thanks very much for your time. Really, really grateful. You've been kind enough to say that you're happy to share a little checklist. So please, if you want that checklist, get in contact with me. I'm sure Jamie's details will be all over that as well. So you can have that there. And I really appreciate your time. Everybody, thank you very much for watching. And I look forward to seeing you to the next one. Thanks a lot. Have a good day.